TPS ends. What you can do if you have a removal deportation order or you entered without inspection.
Greetings. I am attorney Edwin Fogam, an immigration attorney. Our topic for today is TPS, temporary protected status, is ending or has ended for many countries. So what should you do or what can you do if prior to obtaining that status, you had a final order of removal or you had entered the United States without inspection? This is a tough situation. As you know, temporary protected status is a humanitarian relief that is available to nationals from certain countries when it has been determined that a crisis, political crisis, wars, or other humanitarian crisis in those countries. But this is a limited program and ends after the designated period of time. Now, persons who had entered without inspection or who have final orders of deportation may find themselves in a very difficult situation because USCIS will issue notices to appear, referring them to courts and things like that. So what options can you look into? I will give you a couple of them. First of all, you can still look at family-based type of immigration. Now, Section 245I, where you pay a penalty if you had over the years filed any petition that was approvable, can still help you to seek a way of adjusting your status if you have a petition or a petition that can be approved now. You should also consider advance parole if you are traveled out of the country with your TPS and returned on advance parole that was granted to you by USCIS. You may now be admissible to adjust your status if you have a petition filed for you or you have any means of adjusting. Consular processing may still be an option. For those who have petitions that have been filed here and are provable, you may want to strategically look at consular processing, especially marriage-based petition, where you can seek waivers, 601A waivers and 212 waivers abroad. This is an option to look into. But more importantly, you may want to also look at the humanitarian options. The humanitarian reliefs that are available, asylum and withholding of removal. Even though you may have the 10 years bar, you may still qualify by filing withholding of removal under either the Immigration and Nationality Act or the Convention Against Torture. Of course, this will depend on your background, the country you come from, and what you are presenting. You want to also look at U visas, victims of crimes who are assisting law enforcement. That is a possibility. You want to consider VAWA, Violence Against Women's Act. This is also violence against men, where if you can demonstrate that you have suffered physical or psychological abuse by a U.S. citizen, parent, spouse, or child, adult child, or a permanent resident, parent, spouse, or adult child, you may proceed under that. Children under 21 may want to look at the special immigrant juvenile visas situation, where if you demonstrate that you were neglected or abandoned, you may want to go under that. So these are some of the options you may want to look into. All of these options have strict eligibility criteria. So if you want to think about this or do something about this, you have to talk to a knowledgeable person and see how you can be assisted. We will be glad to talk to you or analyze your case for you if you reach out to us. Our phone number is 301-608-1555. You can also send us an email, ekfogam@fogamlaw.com. I hope this information was helpful to you. If it was, you could share it and have other people benefit from it as well. Thank you very much.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.